Tyrants care nothing for discussions that are to end only in discussion. Lysander Spooner didn't pull any punches. He knew that words without action were meaningless in the fight against tyranny. And on this episode today, we're going to explore some of his best and most radical takes on the Constitution. And after hearing them, I think you're going to agree with me that his views are more important than ever. But first of all, before getting to that, welcome and thank you for joining me here on the path to liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, December 11th, 2024. And I want to start out with what I think is probably the most popular, most cited quote from Lysander Spooner. We see it all the time, and I think most of the people who share it with us as some kind of a mic drop or a gotcha have probably read almost nothing else from Spooner other than this one out of context quote. And I think that's a total shame. And I think you'll agree with me after you hear a little bit more of what he had to say. But anyways, he said, whether the Constitution really be one thing or another, this much is certain, that it has either authorized such a government as we have had, or has been powerless to prevent it. In either case, it is unfit to exist. And this is from the one paragraph appendix to a 50 to 60 page publication, No Treason, the Constitution of No Treason number 6, the Constitution of No Authority, published in 1870. Now, what's missing is all the stuff that he wrote before that, all the context. And I think it's a long piece, but I think it's very interesting. He said, inasmuch as the Constitution was never signed or agreed to by anybody as a contract, it's actually a compact. He said, and therefore it never bound anybody, is now binding upon nobody, and is moreover such as one as no people can ever hereafter be expected to consent to, except as they may be forced to do so at the point of a bayonet. And if you think of the time of this in 1870, it was shortly after a lot of people were forced at the point of a bayonet to agree to it. It is perhaps of no importance what its true legal meaning as a contract is. Nevertheless, the writer thinks it proper to say that in his opinion, the Constitution is no such instrument as it has generally been assumed to be. So even here, he's saying the Constitution is nothing how you people are describing it as, especially the people in power. He said, but that by false interpretations, of course, people with power, judges, politicians, etc., supporters of the monster state will always give us false interpretations of what a government is authorized to do. False interpretations and naked usurpations. The government has been made in practice a very widely and almost wholly different thing from what the Constitution itself purports to authorize. He has heretofore written much and could write much more to prove that such is the truth. Now, kind of a TLDR. Spooner is basically saying, I think I've proven that no one signed on to this contract. Whatever, it's not legit. But maybe there's no point because of that in talking about its real legal meaning, but I certainly have done quite a bit of that, and he did it for decades. And what they've twisted this thing into is nowhere close to how it's supposed to be, how we're told what it's supposed to be, how the words themselves have told us what they're supposed to be. Now, Spooner he wrote about the Constitution again for many, many years, about the legal meaning of the Constitution. He had a lot of incredible insight, some of it awesome, some of it not spot on. But I want to first address this most popular quote, the notion that somehow words on paper, if you just get the right ones, a Constitution could prevent what we have. He said it's been powerless to prevent it. Well, of course, words on paper don't stop government. They never did. They never will. This is just absurd. This is a message that we heard from the framers of the Constitution, the supporters of the Constitution, over and over and over during the ratification debates. In fact, they went so far as to call the Constitution a mere parchment barrier that needs outside enforcement. You can't rely on the government itself to limit itself. If you do so, you are going to end up with unlimited power. And in fact, Spooner made that case many times over his career. But anyways, I discussed this notion of a parchment barrier being And it's impossible to stop government if you don't have something else that stops government outside of the government itself. Parchment barrier, ignore truth about the Constitution. I covered that in an episode a few months ago. I hope you will check it out. It will be linked to in the show notes. But anyway, some of Spooner's most important insights were his takes on what is constitutional or not, and how to enforce those things, how to enforce the Constitution when government refuses to follow the rules, how to keep government in check, how to stop usurpations of power. Here he reiterates one of the most common views of the founders and the old revolutionaries. An unconstitutional statute is no law in the view of the Constitution. It is void and confers no authority on anyone. If you're watching the video version, I'm wearing a t-shirt with a very similar take, but from James Otis Jr., all the way back at the beginning of the revolution, that radical change in the viewpoints of the people, starting in 1761-ish. This, quote, an act against the Constitution is void, even the unwritten British Constitution, according to the founding generation and the old revolutionaries. Anyways, an unconstitutional statute is no law in the view of the Constitution. In other words, the Constitution is the supreme law of the land. And when government goes beyond the Constitution, it's unconstitutional. It's a usurpation of power. And he went further. He pointed to the danger of waiting on the government to somehow magically do what it really never does, and that is limit its own power. He said it is no answer to this argument to say that if an unconstitutional act be passed, the mischief can be remedied by a repeal of it, and that this remedy may be brought about by discussion and the exercise of the right of suffrage. I mean, if you think about it, as the closest we ever seem to get to repeal is maybe once every few decades. But they add so many other things on top of it that they're really just throwing us a bone at best. Or once in a while we hear repeal and replace, which is such a scam that no one should go along with that kind of garbage. But anyway, Spooner continued, because if an unconstitutional act be binding until invalidated by repeal, the government may in the meantime disarm the people, suppress the freedom of speech and the press, prohibit the use of the suffrage, and thus put it beyond the power of the people to reform the government through the exercise of those rights. Well, they've certainly done bits and pieces of all of that. They do as much as they can get away with. And what was maybe hyperbole in Spooner's time is really kind of, well, we see things like this play out all the time. Waiting on government to limit its own power is incredibly dangerous. And on top of it, in principle, it's nonsense. He said to say that an unconstitutional law must be obeyed until it is repealed is saying that an unconstitutional law is just as obligatory as a constitutional one. In essence, what you're saying is what's constitutional is what the government tells us is constitutional until the government changes its mind. And that's not the system of the founders at all. And Spooner knew this as well, and he made that same case over and over. To say that an unconstitutional law must be obeyed until it is repealed is saying an unconstitutional law is just as obligatory as a constitutional one, for the latter is binding only until it is repealed. He said there would therefore be no difference at all between a constitutional and an unconstitutional law in respect to their binding force. And that would be equivalent, as I was suggesting before, to abolishing the Constitution and giving to the government unlimited power. And that's exactly how the vast majority of people have treated the system of government under the Constitution is, well, we just got to go along with this until we can convince the government to overturn it, whether through the courts or repeal or whatever. And the people themselves are voluntarily giving the government unlimited power. Anyways, he goes a little bit further. He also acknowledges that mere words on paper, what I was talking about right at the beginning, words on paper don't enforce themselves, even when backed up by an oath. He's recognizing this as well all the way back in 1852. Most of the quotes that I'm citing in this episode are from A Defense for Fugitive Slaves, his essay from 1850, an essay on the trial by jury in 1852. There's also Forced Consent in 1873 near the end, and well, of course, No Treason number 6 was 1870. But anyways, he said, it is of no avail to say, in answer to this view of the case, that in surrendering their liberties into the hands of the government, the people that took an oath from the government that it would exercise its power within certain constitutional limits. So he's recognizing, they take this oath, but who do they give the oath to? Well, and if we're thinking about it, okay, they're giving an oath to the people that they're going to follow the Constitution, an oath to the Constitution, an oath, so help me God, whatever they're saying with it. And that means nothing in practice, because for when did oaths ever restrain a government that was otherwise unrestrained? Or when did a government fail to determine, and this is what we get to, the major problem, allowing government to determine the extent of its own powers is the essence of tyranny. He said, when did a government fail to determine that all its acts were within the constitutional and authorized limits of its power, if it were permitted to determine that question for itself? Well, once in a while, they'll say, well, we made a mistake, but it's not very often. So words on paper, even under oath, they just don't do anything. And, some people will tell us in response to messages like this, and we can cite a lot of similar things from the founders and the old revolutionaries. If you're interested, maybe I can do a follow-up episode tying Spooner's takes with many similar ones from the founding generation. But a lot of people will tell us, you just got to make these politicians feel it. You burn up their phones, send them faxes and letters and protests and show up outside their houses, yell at them, all that stuff. Protest, petition. But Spooner thought this was nonsense, and I think I tend to agree. He said, neither is it of any avail to say that if the government abuse its power and enact unjust and oppressive laws, the government may be changed by the influence of discussion. He said, discussion can do nothing to prevent the enactment or procure the repeal of unjust laws, unless it be understood that the discussion is to be followed by resistance. Discussion, that's just talk. Hey, you're not allowed to do this. Read this section of the Constitution. Don't you know what this means? 10th Amendment says you can't do this. 2nd Amendment says shall not be infringed. They don't care unless they know that there's going to be consequences for violating those limits. And Spooner, this is just what I started out with, said, tyrants care nothing for discussions that are to end only in discussion. Discussions, he wrote, which do not interfere with the enforcement of their laws, are but idle wind to them. Man, really, really powerful stuff. He even also discussed the idea of going to courts, part of the government, to resolve problems of the government itself. My friend Tom Woods often calls this like going to your mother-in-law to resolve or to adjudicate a dispute between you and a spouse. It's not a really smart choice. He said the idea is so constantly asserted that the permanent judiciary, the judges, have a right to decide all constitutional questions authoritatively for the people, is one of those gross impostures by which men have always been defrauded of their rights. Thomas Jefferson said the notion that the judges are the final and total say on all constitutional questions would place us under the despotism of an oligarchy. Not much different from Lysander Spooner here as well. So going to the courts, going to a federal court to stop the federal government from doing what the federal government was never supposed to do in the first place. I mean, maybe once in a while you get a win, and for those people who are working that route, great, but most of the time you're going to get an L. He said, there is not a syllable in the Constitution, this is Spooner again, that makes a decision of the judiciary of its own force and without regard to its correctness binding upon anybody. He said, if a judicial decision be according to law, then it's binding. But if not. Just really, really logical stuff. And he said, this is the idea or the principle that the Constitution is the supreme law of the land. It doesn't matter what government happens to say. Government is only doing okay under the Constitution if it's following the Constitution. And government doesn't have the say over whether it, in and of itself, it has violated itself. He said an unconstitutional judicial decision is no more binding than an unconstitutional legislative enactment. And a man has the same right to resist by force one as the other, and to be tried for such resistance by a jury who judge of the law for themselves. Now, Spooner considered jury nullification one of the most essential tools to protect liberty. He called it a palladium of liberty against the oppression and tyranny of the government. Jefferson considered it the only tool ever created by man by which a government can be held to the principles of its constitution. That's a paraphrase, but it's pretty close to what Jefferson had to say about that. I covered both of them, plus much more detail in another episode just a couple of months ago. Jury nullification, the people's secret weapon against tyranny. It should not be a secret. We should all know about it and use it as much as possible. Unfortunately, this is definitely... we don't get a lot of reach on those types of things, but that'll be linked to in the show notes as well. A lot from Spooner's essay on the trial by jury in 1852 on that. A lot from the founding generation, Jefferson and others. That will be in the show notes at 10thamendmentcenter.com/path to liberty, which Alan Mosley does a great job of organizing. There's a show links section. We get a blog post published for every single episode, and Alan organizes the show notes section kind of along the lines with all the links, the stuff that I'm mentioning, the source documents, the essays, other episodes, articles, whatever I happen to be mentioning in each episode. They're generally in order of how I go through them throughout the show. That way you can read and learn more in context on your own time, or if there's other episodes like the jury nullification one, you got another one to check out because it's really important stuff. Alan will get that organized and I will get it published over at 10thamendmentcenter.com/path to liberty a couple of hours after this live stream is done. But anyways, let's get back to Spooner. I want to hammer this out here because this is such awesome stuff. He's talking about resistance, and of course, using the tool of jury nullification to help protect people who might be harmed by government for resisting what government wasn't supposed to do in the first place. He said, but for this right on the part of the people to resist usurpation on the part of the government, I should make a just a quick comment on the term usurpation. This is a very important one. This is what the founding generation, the old revolutionaries, considered a theft of power by government. If government is only authorized to do the stuff that the people say that they can do in a constitution, written or unwritten, doesn't matter, anything beyond that is stealing power that it didn't belong to them. This is a usurpation of power. St. George Tucker called this treason against the sovereignty of the people. Treason against the final authority of the people. And even Alexander Hamilton said, when they go beyond the limits of the Constitution, these are not supreme. These are acts of usurpation and deserve to be treated as such. And if usurpation is treasonous against the sovereignty of the people or just really bad, treating it as such doesn't mean getting on your knees and begging them to stop doing it. It's taking much stronger action, whether it's a refusal to cooperate or more direct resistance as well. And the latter is much more in Spooner's line. He said, but for this right on the part of the people to resist usurpation on the part of the government, the individuals constituting the government would really be, in the view of the Constitution itself, absolute rulers, and the people absolute slaves. So if government gets to determine if government followed the rules or not, and the people can do nothing about it other than wait for government to change its mind and say, oops, we made a mistake, you're living in an absolute tyranny. The founding generation called this arbitrary power. Arbitrary power was one of the so-called grievances, the injuries and usurpations that were listed in the Declaration of Independence. Submitting to arbitrary power is not an honorable thing. We all do it, but we got to do it less. Anyways, the oaths, Spooner wrote, required of the rulers to adhere to the Constitution would be but empty wind as a protection to the people against tyranny if the Constitution, at the same time that it required these oaths, committed the absurdity of protecting the rulers when they were acting contrary to the Constitution. Man, such awesome stuff. And just like the founders and the old revolutionaries, he saw the right of resistance as the way to keep government in check. James Iredell, one of the first associate justices on the Supreme Court, said, the people will resist if government usurps power. Resist. Not stand idly by and beg them to stop. An act of usurpation deserves to be treated as such, even Alexander Hamilton. Jefferson said a nullification of the act is the rightful remedy. That isn't just saying, oh, we're nullifying and writing it down. No, the people in Kentucky, the militias, were really geared up to try to stop the Alien and Sedition Acts if they couldn't stop it in other forms. Anyways, the right of the people, therefore, to resist usurpation, said Spooner, on the part of the government, is strictly a constitutional right. I would suggest it's part of the first law of nature. the right or duty of self-preservation, and, of course, the right of self-defense. He said, and the exercise of the right is neither rebellion against the Constitution nor revolution. It is a maintenance of the Constitution itself by keeping the government within the Constitution. When government usurps power, they're the ones in rebellion. They're rebelling against the rules. And allowing them to get away with it only guarantees that they're going to do more and more as well. Spooner had this juicy add-on as well. It is also a defense, this resistance against usurpation is also a defense of the natural rights of the people against robbers and trespassers who attempt to set up their own personal authority and power in opposition to those of the Constitution and people which they were appointed to administer. Such good stuff. Now, Spooner was one of the most ardent supporters of the Second Amendment. And he didn't say you should just have a Second Amendment just to have it. It's there to use it. And it's not just about hunting and defending against your local robber, but it's a defense against tyranny. And certainly this is what all the founding generation said. Melancton Smith told us to preserve liberty. It's essential that the entire body of the people always bear arms, always possess and bear arms. Again, a paraphrase. Spooner said an officer of the government is an officer of the law only when he is proceeding according to the law. The moment he steps beyond the law, he, like other men, forfeits its protection and may be resisted like any other trespasser. No one in government will ever agree with this. But this should be the principle of the people. If the people have final say and this is how they treat government, well, then government will be in check. That's the whole mentality. He said, if this doctrine were not true, and if a man may, if he choose, execute an authority granted by an unconstitutional law, Congress may authorize whomsoever they please to ravish women and butcher children at pleasure, and the people have no right to resist them. Now, certainly there was some level of hyperbole here, but like John Dickinson said in 1767, regarding the Townshend duties, the taxes, which were considered pretty small at the time. They would never have raised the money needed by the British. It was there to establish a precedent. And Dickinson recognized this. He said, if they can tax us at 1 penny, they can tax us for 1,000,000. Because where does it end? And Spooner's making a very similar point. If they have the right to enforce and execute an unconstitutional law, they can pass whatever they want. It's just only a matter of time. And maybe this is a big part of the reason why we're like, oh, well, how did things get so out of hand? Well, they get out of hand because of this. Spooner said the Constitution contemplates no such submission on the part of the people to the usurpations of the government or to the lawless violence of its officers. On the contrary, it provides that the right of the people to keep and bear arms shall not be infringed. And he said this constitutional security for the right to keep and bear arms implies the right to use them, as much as a constitutional security for the right to buy and keep food would have implied the right to eat it. So, pretty hardcore supporter of the natural right of self-defense, the Second Amendment, and the like. Now, of course, as I mentioned right at the beginning, I think he went off the rails a bit with this claim that the Constitution caused what we live under. Now, certainly a bad Constitution will make it more likely that you end up with a giant government. A good Constitution will make it more likely that you have a smaller government. That's really what Dickinson and many of the other founders told us. But words on paper, again, they don't enforce themselves. They never did, never will. And I think Spooner, because he wrote so many years about the lawlessness of government at the time, about consent, about the limits of power, he saw over and over and over just total disregard for these types of things. How to keep government in check, not being followed. He saw a government doing what it wasn't supposed to do. It made a mockery of the principle of the consent of the governed over and over and over. I think this essay, written in 1873, I think the timing is very important. It's just a few years after his No Treason. It's also just a few years after the war between the states, the so-called Civil War. I think this essay adds a little kind of insight, some context into where his mind was going, what he was thinking. And he said, mind you, this is an abolitionist, an ardent abolitionist. I know in our realm, it's not unusual for an abolitionist, someone who's opposed to all kinds of usurpations of power, someone who is opposed to much of what the Union did, don't like Lincoln. We hear a lot of people like that. Brian McClanahan's a friend of the 10th Amendment Center. You'll hear plenty from him on this. Tom DiLorenzo, Woods, many others. But generally, the mainstream, if you attack Lincoln as being a tyrant, they're like, oh, what? You love slavery, neo-Confederate? They're just dumb about these types of things. But Spooner was obviously a very, very intelligent dude. He was no fan of Lincoln. And Spooner was way more hardcore on abolition of slavery than Lincoln ever would have dreamed of being. Anyways, Abraham Lincoln did not cause the death of so many people from a mere love of slaughter, but only to bring about a state of consent that could not otherwise be secured for the government he had undertaken to administer. He said there never was, and there never will be, a more gross, self-evident, and inexcusable violation of the principle that government should rest on the consent of the governed than was the late war as carried on by the North. He said there never was, and there never will be, a more palpable case of purely military despotism than is the government we now have. And I'm not an expert on Reconstruction, but it was kind of in that time, and I don't think he was a fan. And here he is again, talking about the moral duty to defend the liberty of the people. He said, when the government fails to protect the people against robbers, kidnappers, ravishers, and murderers, it is not only a legal right, but an imperative moral duty of the people to take their mutual defense in their own hands. And again, supporting the Second Amendment, he said the Constitution recognizes this right when it declares that the right of the people to keep and bear arms shall not be infringed, for the right of the people to keep and bear arms implies their right to use them when necessary for their protection. That, I think, was, this was 1860, the address of the free constitutionalists to the people of the United States. Him, again, being a very strong, ardent abolitionist and willing to use the natural right of self-defense to protect people who were being enslaved. This was his argument, and he also thought Lincoln was a total tyrant. But anyways, for a long time, Spooner took the position that the idea, the notion, the principle of the consent of the government was really just a theory, but in practice, it was a total sham because you could never really get all the people to consent. And I did an episode covering that earlier this year, John Locke versus Lysander Spooner on the consent of the governed. I think it's really interesting stuff. Whatever side you take on that, maybe you take none of them or a little of both, but that will be linked to in the show notes as well. Now, of course, we kicked off this episode, opened up with Spooner's most cited quote from No Treason number 6, the appendix, saying that the Constitution created was powerless to stop what we have or created it. But right before that, I think, is his most important quote, the end of that text of No Treason number 6. And I think this is our takeaway for all time. The lesson taught by all these facts is this: as long as mankind continue to pay national debt, so-called, that is, so long as they are such dupes and cowards as to pay for being cheated, plundered, enslaved, and murdered, so long there will be enough to lend the money for those purposes. And with that money, a plenty of tools called soldiers can be hired to keep them in subjection. I mean, this is straightforward stuff. As long as the people keep going along with this stuff and keep coughing up the cash to pay for it, government will never, ever stop. But, Spooner said, when they refuse any longer to pay for being thus cheated, plundered, enslaved, and murdered, they will cease to have cheats and usurpers and robbers and murderers and blood money loan mongers for masters. And I think it should be no surprise that government-run schools don't teach us about Lysander Spooner. Maybe you heard his name, but this is not the kind of stuff that they're going to teach us. Even the things that really echoed the same types of messages from the founding generation. An act against the Constitution is void. Resistance to usurpation is how you stop that usurpation. But, well, The 10th Amendment Center has you covered, and nothing helps us reach and teach more and more people with these essential foundational principles more than the financial faith and support of our members. If you got a couple of bucks of that quickly devaluing dirty government fiat, please consider throwing it our way. Our membership program starts at just $2 a month over at 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. I'd be very grateful for any consideration you can give to joining us today. And while we're here, I want to say a quick but very big thank you to just a handful of people who have joined us as members. Thank you so much for your support. Keith in Utah, Leanne in Montana, Joseph in California, Theodore in Hawaii, Thomas in Washington, and Anna in Ohio. I'm extremely grateful for your support. Thank you for being a part of this. There's a bunch of other things that you can do if you're not ready or you're not willing or able to pitch in financially or do a one-time donation over at 10thamendmentcenter.com/donate. There's a bunch of free and easy peasy ways you can help us spread the word, primarily through taking actions that can trigger algorithms of the mainstream platforms, like reviews on any of the podcast platforms, subscribing, getting notifications, hitting the like button, comments in the archive. The more, especially like on the video platforms, the more time you spend watching the video actually tells them to show it to more people. So put it on the background, listen to it a couple of times, whatever. I appreciate all the help. I hope you enjoyed this episode. I hope it made you think. A lot of really deep, hardcore stuff here that many of us probably aren't ready to hear all the time, but I think it's really essential. These principles are more and more important than ever, especially as we live under the largest government in history, and it doesn't ever seem to stop growing. So thank you so much for being here again. I hope you enjoyed this episode, and I hope to see you next time here on the path to liberty.